Hello and welcome to our Success Tips and Helpful Hints series. This particular training will be on the role of the Independent Hearing Officer. This was developed by the Independent Hearing Officer Work Group and is sponsored by the Council of State Administrators of Vocational Rehabilitation. So with all of that said, let's get started on some success tips for you. So what does an independent hearing officer do? Independent hearing officer hears an issue raised by an individual regarding a disagreement about a decision made by the VR agency, and then the independent hearing officer decides the outcome. So the person acts sort of as an independent layer, an independent decision maker in that role. And IHO is responsible for the conduct of the hearing and ensuring that the issues are reviewed in a fair and impartial manner. So, in some cases, clients can feel particularly challenged by an agency. The IHO process was developed to ensure that a client would have a fair and impartial way of making a decision on a disputed issue. So that's really the basics of the role. Let's look a little bit deeper here. So really the key to this role is impartiality. A client may feel challenged by not feeling as though the agency is going far enough to help them, or feeling like they're in need of something that the agency is not providing. The agency might feel challenged by, hey, we've done everything we can, or we don't feel like this is something that we can do. We don't feel like it's something that we're required to do. And so both parties needed a venue outside of the regular VR infrastructure, an independent and impartial person to sort of come in, hear the issues, and make a decision about that. So the impartiality aspect of the role of the IHO is central to its actual function. So notification, some best practices around notification. So when it comes to the hearing officer, the agency would want to make sure, and the IHO from an ethical standpoint want to make sure that you have no personal or financial interest that could conflict with your ability to be objective in that situation. And the agency also wants to do that, make sure that they're picking somebody who isn't, say, a friend of the consumer or is going to have trouble being objective, from the other side. And the IHO should disqualify themselves if there's any uncertainty that their impartiality is in question. Again, central to the role and function of the IHO is the impartial nature of it. So if as an IHO you're wondering, well, I sort of know this person a little bit, or the consumer, or I'm friendly with the office staff in this particular office, and that I'm not sure that I can be objective, then you should disqualify yourself and bring somebody else in. Again, objectivity and impartiality are crucial here. Exparte communication. That's an important piece, and a lot of people don't quite understand what that means before, after, and at the hearing, and what does an IHO do if it happens, how is it avoided. Ex parte communication is discussing the material facts of the case with one party without the other party present. That's why it's called ex parte. And so what's ex parte and what's not ex parte is a question. When the hearing is scheduled is generally not considered an ex parte communication. So, that can happen, the hearing officer kind of going back and forth to say, okay, what days is the agency available? What days the client available? Those don't have to necessarily be three-way calls. But any communication that relates to the facts or the merits of the case absolutely has to be discussed with all parties present. Otherwise, it's considered ex parte communication. So, it's important to be able to say when you get into the hearing, I note that I haven't discussed the merits of the case with either party without the other party present, right? Well, how do you avoid that? Any communication that you have with both parties that's going to that stands a chance of having the merits of the case mentioned should be with all parties present. So that's a good way to avoid that. If you're communicating by phone, for example, it should be a three-way call. Technology is making that a little bit easier, but again, you want to at all times try to have those meetings. If you're going to have a meeting with everybody present, you're going to want to try to do that in person if you can, and the best way to do that is to get everybody present. So the best way to avoid ex parte communication is to, at the beginning of each call, say, I note that I'm not going to talk about the merits of the case. This is just a scheduling call. Or if you're going to talk about the merits of the case, you have everybody on the call. Very important piece. That way, no party is disadvantaged by that ex parte communication. It's a very important piece of the impartiality process. Preparation. You want to prepare an opening statement to help the parties understanding the nature of the hearing, its procedures, and help set the tone for the hearing. We're going to talk in a little while about the use of pretrial conferences to firmly establish issues before a hearing gets started. It's one of those best practices that can really save a lot of time in a hearing. Oftentimes, it can save hours and hours of hashing things out if you can do that briefly before the hearing starts. Remember that a hearing is expensive in terms of time and resources. So the more you can do to make that hearing efficient, the better. And preparing an opening statement is very helpful. It sets the tone for the hearing, it sets the expectations for everyone, and it sets out sort of the clearly the issue at hand and how the hearing is going to proceed. Review the notification letter and applying information sent to all parties involved. It's important that the hearing officer have a role in reviewing that information for fairness, for content, for those kinds of things. Contact the agency's quality assurance representative if there are any questions identifying issues that need to be involved. So, if you've got an issue with the notification letter, or if you've got an issue with sort of the issues as they're being described, for example, it's good to connect with that QA person to make sure that you can get those issues resolved. Requesting a copy of the VR policy and procedure that was current at the time that the IPE was implemented, or any other relevant documents. This is an important best practice. What you want to do is request the policy and procedure manual that was current at the time that the issue under dispute happened. That way you have a very clear reference to the actual policies and procedures that were in place at the time of that incident. It's a really important cornerstone for you to be able to know that you have the appropriate policies and procedures in front of you to be able to make good decisions about that. Here's what we mentioned a few minutes ago, a pre-hearing conference. These are used very effectively to do a number of things. They can be used to discuss any necessary accommodations. We are dealing, sort of by nature of the process, we're dealing with folks with disabilities. They may or may not need accommodations. That kind of issue is best addressed, obviously, and planned for, and a pre-hearing conference gives you the opportunity to do that. Creates timelines for discovery, things like when do all the documents have to be received by both parties. Briefs, either party may submit legal briefs, for example. Exchange of exhibits and witness lists. Hearing dates, clarify procedural matters, accommodations, translators, transcriptionists, recordings, however that's going to work. It gives you the opportunity, with all parties present, again, to take care of some of these scheduling issues. It also gives you the opportunity to better identify the issues and the scope of the dispute. We've had experience on the panel of pre-hearing conferences, in some cases resolving the need for the conference. Once the issues have been clearly decided or clearly identified, the parties were then able to kind of go back to each other and reach a compromise that avoided having a hearing be necessary. In other cases, the issues were clarified to such an extent that it saved a tremendous amount of time in the actual hearing in hashing out the issues at hand. So very important. And also to clarify procedures involving witnesses and working out logistical issues. Let's say that there's a witness proposed, and you're at a pre-trial conference, and there's back and forth about, well, this witness is going to testify to this, and this witness is going to testify to that. If if at some time you're thinking, this is really not a relevant witness, the testimony wouldn't be relevant to the actual case, and the parties can understand that, then they can eliminate that witness, and it saves them the time, expense, effort of bringing that witness in, and it lets you kind of resolve some of those issues. In other cases, let's say that it comes to light that there's a specific witness that could be helpful, could be very relevant, and one party or another wasn't aware of that before. A pretrial conference can give you the opportunity to discover some of those things. So it gives you some clear advantages from a procedural and planning standpoint, and also from a process and substance standpoint in identifying the issues. So some preliminary issues. You want to discuss the administrative aspects of the hearing, conduct expected at a hearing, what's a recess, what's a motion, what's discovery. Remember that this process is not, it's not one that people go through on a regular basis. So, when you're holding the preliminary sort of words at a hearing, talking about things like, if people need a bathroom break, you feel free to request one, where those restrooms are. And in some cases for our consumers, that's vital information. That's not just convenience information, right? We also want to be clear about, discovery. If one person has a piece of evidence, then obviously the other party is entitled to that evidence too, if it's going to be presented in evidence. And again, this isn't a process people go through on a regular basis. So it's important to be able to clarify some of those things up front. If you're going to have witness testimony by phone, if you're going to have accommodations to meet disability, again, pretrial conference can clarify a lot of those things. But saying some of those things, again, when the hearing starts, can help people to sort of orient themselves to the process and the function of the hearing. Begin the hearing on time, very important. People are there, and in many cases for consumers and for agencies, they've taken tremendous time, energy out of their day to get there. So it's incumbent upon us to start things on time. If everybody's not present, you should leave some reasonable leeway. There's traffic, and a lot of times people traveling from agency work can get a little tense and overwhelming at times. Clients can have significant medical needs, so it's important to be a little bit flexible and have some leeway there. And then preparing the opening statement to help the parties understand the nature of the hearing, its procedures, and help set the tone. Really important that we the more we set expectations, the more that we're clear, on policy and procedures and how this is going to work, the more comfortable people can be, and the more objective and cleaner the hearing is. A couple other preliminary issues. You want to assure that the proceedings are properly recorded. It's a really important thing to have a recording of a hearing. Some agencies, some jurisdictions do sort of a court reporter and a transcripted recording. That can be tremendously helpful in going back, and especially when you're working through the findings of fact in a decision, for example. It's hugely helpful to be able to say, and in the transcript, page so-and-so, line so-and-so, this statement was made, and I'm giving weight to this statement for this reason. It's very clear, it's very clean, it's very concise, and it ends up developing well-organized decisions as well. Identifying how the exhibits are to be marked and listed. There's some best practices around that. We will probably do another training on that. But having a mark for the petitioner and a mark for the respondent is always a good thing when things are submitted. And that way it's very clear not only that they were submitted by the petitioner or the respondent, but also what order they were presented in. So if we have a symbol for the petitioner and that's petitioners 1, and we have a symbol for respondent, and that's, okay, that document is respondents 1, it's very clear how and when that they were presented. And then if you ever to go back to review that evidence, you can very clearly get to, okay, petitioners 1 was presented at this time, and they're noted on the form as well. You can narrow or clarify the issues in preliminaries in a lot of cases. And again, pre-hearing conference give you that opportunity as well. And you always want to provide a witness sign-in sheet. As a best practice, you should have a sign-in sheet for everyone at the hearing, in addition to a witness sign-in sheet as well. I often combine those into one sheet. I'll have petitioners, respondents, witnesses, and then that way it's very clear. And make sure that people write legibly on that to the extent that's possible, and that way you can identify all the parties that were present at a given hearing. Again, the basis and function is impartiality here, right? So, and appearances can influence that. So here's a couple of best practices around maintaining confidentiality. Let's say the hearing is going on. Try not to have a lot of informal, chatting, those kinds of things happening with one side or another. Certainly feel free if you want to have coffee in a hearing, or you want to have tea in a hearing, you want to have some refreshments there, some water there. That can help everybody be more comfortable. But you don't want to be seen to be hanging out with the staff and chatting with the staff by the petitioner, because then the petitioner could think, oh, that person's just friends with everybody here and less and more impartial. Same thing in the reverse, right? You don't want to be kind of hanging out with the client the whole time and have the agency perceive you as less than impartial. No conversation in the waiting room with participants and attorneys unless everybody is present. Important to remember that ex parte communication thing exists throughout the hearing. Chatting upon breaks or exits, it's an important thing that again that you appear impartial. You're not favoring one or the other with your friendship, attention, those kinds of things. Walk into the room separate from both the participant, agency, and staff. You want to be clear that you weren't out hanging out with the petitioner, you weren't out hanging out with the staff. You're your own independent hearing officer. And the use of formal terms, Mr. or Mrs. That helps you to kind of avoid the appearance of familiarity or friendship with any given party. Again, some best practices to be sure that appearance-wise you're meeting that impartiality definition as well. So the duties here, commonly encountered categories of issues. So what are you likely to see? What are you likely to encounter as a hearing officer? Well, you're probably going to have a case at some point about applicant eligibility for VR services. There's likely going to be some disagreement at some point, in some case or another, over the nature, scope, or content of the IPE. The quality or nature of the counseling services that were provided by the vocational rehabilitation counselor. That can be an issue at times. The delivery or quality of other VR services. Certainly the cost of services can be an issue. Termination of services or service record closure. And then there could be other complaints and issues as well. What we've tried to do here is just kind of give you a list of some of the, kind of the basics that you're going to encounter. And then that way, if you see this list and you think, wow, I don't know much about a part of this, or I don't know enough about a part of this, you can in advance sort of get, go grab the RSA guidance on eligibility. Go grab the RSA guidance and look in the CFR on the development of the IPE and the nature and scope of that. And that way you're prepared if you get an issue that comes to you and it's sort of one of these commonly occurring ones, and you've actually done some advanced research on it, you've got an idea, you'll be much more comfortable in developing the hearing, and I think you'll be in a place that you'll be a little bit better prepared. So what other duties do we have? Well, we want to receive and consider all the relevant and reliable evidence. We want to ensure an orderly presentation of the witnesses and issues, and we want to oversee the preparation of the record. Remember that these are sort of quasi-judicial proceedings, so that we want to make sure that as the IHO, we're responsible for it maintaining a clear and appropriate record of this entire process. So it's important to know that the hearing officer has a key role in that. So when we're talking with an agency and we're talking about, we need a quality recording of the hearing, we want a transcript of the hearing as well. That's part of fulfilling our responsibility to overseeing the preparation of a clean and accurate record. We also need to assess the credibility of witnesses and the authenticity of evidence. It's an important part of the role of the hearing officer to hear the evidence and decide to which evidence we give more or less weight. Very important piece of that. And we need to be able to articulate that process clearly and efficiently. And when we talk about writing the decision and you look at that training, we'll talk about that in a little bit more detail. We need to reach a fair and independent and impartial decision. That's an important piece. And that needs to be based on the applicable federal law, agency policy, procedure, and state finance rules. So it's important for us to be aware of. That's why we request the policy and procedure manual in effect at the time that the issues became identified. That's why we look at the Code of Federal Regulations. That's why we look at the RSA guidance. That's why we look at some of the sub-regulatory pieces out there that can give us some guidance. That's why we look at state law. A very important piece of that. The other thing is the IHO should mediate a hearing. Mediation is actually a separate process. Must be made available to individuals to choose to resolve disagreements concerning agency decisions. Mediation services are provided typically by different folks than those that provide the IHO services. Now, there can be some exceptions to that, but in general, if you're in an independent hearing situation, you are not by definition in a mediation situation. And I think sometimes it gets a little tempting to want to mediate those kinds of things. But an independent hearing is a separate process from mediation. Many agencies are wanting to use mediation a bit more, and there's clear advantages to that. And I would encourage those who are interested in mediation to go get some training in mediation. But I wouldn't. I would caution you to know what your role is moving into a situation. If an agency approaches you as an independent hearing officer, then that's your role. Your role isn't as a mediator at that time. And finally, the IHO needs to ensure that the VR agency and the participant have copies of the exhibits at the conclusion of the impartial hearing. So let's say the hearing's going on, somebody, the petitioner or the consumer submits a piece of evidence. Well, the hearing officer should ensure that a copy is made so that both parties have a copy of all the evidence that was submitted. Same with anything that the respondent or the agency submits. The part of the process of maintaining a clear and accurate record is ensuring that everybody has access to all of the evidence. And that way, when you write your decision, and you're saying, well, yes, I relied on petitioners 4 here, then when each party is reading that decision, they can go directly back to that piece of evidence, and they will then have a copy of it. So a few tips here on the hearing itself and conducting the hearing. An impartial hearing is an opportunity for both sides to present evidence on something on which they disagree. It's not a legal proceeding. It is a quasi-judicial proceeding. But it's not a legal proceeding. The decision is going to be based on laws and state statutes and federal regulations and all of those kinds of things. But we're not in court here. And it's important to remember that it shouldn't be perceived as a court case. It also isn't just a roundtable discussion. It's kind of somewhere in the middle. And so the way to present that is to say, this is an opportunity for both sides to present testimony and evidence, and at the end of this process, we're going to make a decision on an issue that's in dispute by both parties. And setting some expectations around that, setting some rules around all that is why that we suggested some of those preliminary comments earlier. But important to remember that it's not as formal, it's not as a hearing in court, and it's not as informal as just getting everybody around the table and chatting. It's somewhere in the middle. And control of the hearing is crucial to accomplishing this end. So the hearing officer's role is really to be very clear, set expectations, set some guidelines, make sure that people are aware of what the expectations are, and to clearly and fairly conduct the hearing. Burden of proof, really important piece of this. The party who initiates the impartial hearing has the burden of proof. So typically, it's the consumer that has the burden of proof, with one exception, and that is presumption of eligibility. In that case, the agency has the burden of proof. So the burden of proof means that the person must present substantial evidence supporting their contention that he or she, in the case of a petitioner, that he or she is entitled to the services or actions requested. In the singular case of presumption of eligibility, when the burden of proof shifts to the agency, they have to present substantial evidence supporting their contention that their presumption of eligibility actions were correct. Okay, so important to remember that the majority of the time, the consumer bears the burden of proof. Opening the hearing. And again, this is part of what we talked about before. Some preliminary comments to open the hearing helps set expectations. But opening the hearing with those helps parties to understand the nature of the hearing and its procedure, and it'll help set a tone. So let's look at opening remarks here. Typically, there's a call to order, right? Getting everybody together. There's an introduction of the hearing officer. Now, in a lot of cases, especially if you've had a pre-hearing conference or you probably have had some connection and some contact with the parties already, this introduction of the hearing officer can be pretty brief. The purpose of the hearing, identifying the clearly what's at issue. That's it. That's an important piece here. What are the procedures of the hearing? Some of the mechanics of the hearing. Rights to appeal. It's very important that people know right up front the rights that they have within the hearing with regard to examining documents and examining documents of the other party, and the rights they have to appeal if either party disagrees with the decision. Introductions of the participants, for the record, of the parties involved, and then giving the opportunity for opening statements. Receipt of formal and written testimony. As they do in a court case, again, this is quasi-judicial, the witnesses are sworn in. So they swear to tell the truth, the whole truth, and nothing but the truth. They typically say their name. That's an important piece. Identifying who the witnesses are going to be is an important piece. And typically you've identified that on the front end. Again, the best practices of pre-hearing conferences and lots of discovery and conversations, including all parties. You've kind of got a lot of this stuff squared away, but we need to list those out. And we're receiving what kind of evidence and testimony? Well, there are witnesses, there's documentary evidence, cross-examination. So let's say that a person testifies, the other side has the opportunity then to cross-examine or to ask that person questions about their testimony. You can object to testimony, but it's important to remind everyone that objections need to be based on a legal issue. It's not just that, I disagree with that person says. There has to be a valid legal reason for an objection. And questions from the independent hearing officer. Typically, the way I present this and the way that best practice is when somebody is sworn in, this is a time for your testimony. You say to the other party, if you hear anything you'd like to ask a question about, I'd encourage you to write that down. Please don't interrupt that party. Again, that's a part of keeping that clean record that we talked about. But write any questions down that you have for that person, and you'll have the opportunity to cross-examine or ask questions of that person at the appropriate time. Some people get tempted to jump right into their testimony and cross-examination. Well, I disagree with what that person just said because. If you do that, I'll kind of gently guide you back to this is just about questions for this person. You have questions based on their testimony. If not, you can jump into your own testimony, but, So it's important to separate the questioning and the testimony. And it's important to say you can object to a person's testimony, but you have to have a legal objection to that. It can't just be that I disagree. And it's important that the hearing officer reserve the right to ask questions throughout the process. Other pieces, default. If one party, fails to show up for the hearing, for example, that needs to be noted and a conversation had, again, not ex parte, but with all parties as soon as possible. Going off the record. So in many cases, you'll have a situation where maybe a witness needs a little bit of time to have a pause or take a break, or let's say that somebody really needs to gather a piece of paper that they can't find, for example. It's very appropriate to say, okay, we're going to go off the record for a moment, pause the recording so that person can take care of what they need to. That same thing happens with things like restroom breaks or those kinds of things. It's inappropriate to continue a hearing with anybody that's a relevant party out of the room. So if that person needs to use the restroom, if that person needs to, it's important to pause the record, go off the record, take that time, and then come back. Same for recesses, right? If the hearing is going really long and people are really fatiguing, remember that can adversely impact the clarity and the quality of what people are offering. So it's appropriate at times to take a brief recess, 10, 15 minutes, to let people take a break, recharge, and then come back. And then postponement can happen as well. There are times when life happens to people, life happens to respondents and agency folks and petitioners. And so we need to be flexible enough to say, okay, let's postpone the hearing to X time. Remember, though, that hearings cost time and money, and there are a tremendous amount of resources invested by all parties. So we need to be sensitive that we're not doing that in a cavalier fashion, that we're doing that in a very intentional fashion. You may have some other ideas as well. So concluding the hearing, now we're at a point where all parties have been heard. And we asked the parties, is there anything further that anybody would like to contribute? Really important that we get that on the record, and that people say, nope, that's everything. We give the opportunity for closing statements at that point to both parties. Closing statement is not required, but is a brief summary of what you think you've proven today. You may or may not have a closing statement, that's fine, but each party has the opportunity to deliver that. Transcripts important to, at this point, if you're going to have if you've got a court reporter in the room, for example, and you're going to have transcripts of the hearing, that you clearly identify, this hearing has been transcripted, all parties will receive a copy, asking the transcriptionist, by what date will that transcript be available, and so that everybody's clear that they'll have a full record of the proceedings at a given time. You want to also be clear that, I will have my decision to you in writing by X date. You want to be very clear that you acknowledge, and there are certain time frames called for and I would consult your contract, your independent hearing officer contract. There's some requirements around that as well. Typically it's 30 to 60 days. In most cases it's 30. But again, consult that. Make sure that you're promising delivery within that time frame. And then it's also really important that you close the hearing effectively. Why? Well, it's important that if the transcript are reviewed or the record you go back to, it's part of maintaining a clean record is knowing when the record ends, right? So saying something like, okay, if there's nothing else, we're going to go off the record. It is so-and-so time on so-and-so day. That will conclude the hearing, and then we stop the record. That way, if somebody goes back and says, well, we weren't sure if there was any testimony after that. No. We closed the record at this time. It's very clear and clean. So important to remember that there are some processes to follow to ensure that you have that clear and clean record. So here's a little guidance on some specialized areas that we're finding are increasingly relevant. As a result of WIOA, there's an increased focus on things called pre-employment services. And pre-employment transition services are designed to be like kind of an early start at job exploration for students with disabilities and should enrich and not delay transition planning and application of the VR program. The Rehabilitation Act was amended, and it commits state VR programs to be involved in transition planning as early as possible. So the inclusion is not intended to shift the responsibility for service delivery from schools to VR. It's important to remember that. It doesn't just, shift the responsibility earlier. That, well, VR should take over this person. No, that responsibility is maintained by the schools, but it does require VR to get involved in a little bit earlier in the transition years. Schools will continue to be responsible for providing transition and planning services, but there's an expectation that VR get involved a little bit earlier, start to collaborate in the planning process, and it's important to note that due process rights can be exercised by eligible students who have applied for VR services, as well as potential eligible students who have not applied for VR services. So again, important to remember that because of some of the shifts in WIOA, you may begin to see issues like that be presented, and it's important that you become familiar with what's in WIOA, what's in the Rehabilitation Act and the amendments, so that you can respond to those appropriately. So a couple things to keep in mind with regard to these potentially eligible students. Important to keep in mind that they're eligible for respective states' CAP programs. Are eligible for advocacy through those programs, whether they've applied or not, or been deemed eligible or not. Really important to remember that piece of it. And also important to remember that 361.57 in the CFR was amended throughout to make clear that recipients of VR services may exercise due process rights when disagreements arrive during the receipt of pre-employment transition services. So the CFR has been sort of refined to ensure that these folks have some due process rights. So important to remember, you might say, well, they have not applied for VR services, so, an agency might say that. Well, 361.57 has been amended to say whether they applied or not, they're entitled to some due process rights. So again, just things to think about as you encounter some of these issues that we may be encountering more and more as the law transitions and changes. So we'd like to thank you for tuning in. Our contact information is included with these materials. We'd love to hear from you. If you've got specific challenges that you'd like to see us talk a little bit about, we're happy to do that. If you've got ideas about how we can improve and enhance these training materials, these supporting materials, we would love to hear from you. Thanks again. Looking forward to working with you to make your hearings more effective and more efficient. Thanks so much. We'll talk to you soon.